Picture this, you've just bought your first home. It's a perfect little house, your own slice of the American dream. You decide the first thing you want to do is make it truly yours. So you head to the hardware store, pick out a gallon of the most vibrant, cheerful shade of sunshine yellow you can find for your front door, and spend your Saturday afternoon carefully applying the new color. You stand back admiring your work, feeling that surge of pride and ownership. And then, a few days later, you find a formal letter in your mailbox. It's from your homeowners association informing you that your beautiful yellow door is a violation of community standards. Apparently, door colors are restricted to a pre-approved palette of what can only be described as 50 shades of beige. Your personal expression has just run headfirst into one of the weirdest, most specific, and often most baffling realities of American life, the strange world of housing rules and laws. Across the United States, tucked into city ordinances, buried in neighborhood covenants, and enforced by local officials and homeowners associations, there exist thousands of regulations that govern nearly every aspect of what you can and cannot do with your own property. These aren't just simple safety codes or zoning laws. We're talking about rules so peculiar, so oddly specific, that they seem to defy all logic. They dictate the types of curtains you can hang, the kind of car you can park in your own driveway, and even whether you're allowed to have certain plants in your garden. It's a hidden legal landscape that can transform the simple act of homeownership into a bizarre maze of do's and don'ts, where something as innocent as a garden gnome or a clothesline can become a source of major legal conflict. In this video, we're going on an investigative tour deep into this peculiar universe. We'll uncover some of the most head-scratching housing regulations from coast to coast, from towns that have outright banned certain colors of paint to cities where it's illegal to have furniture on your own front porch. We'll explore where these rules came from, why they persist, and the surprising ways they shape the communities we live in. So get ready, because we're about to dive into the wonderfully weird laws that prove that when it comes to your own home, you might not have the final say after all. Our journey into America's strangest housing laws begins in a place renowned for its stunning beauty and rich cultural heritage, Santa Fe, New Mexico. But beneath the surface of its picturesque adobe buildings and sun-drenched plazas lies one of the most rigorous and specific color control ordinances in the entire country. In Santa Fe, the color you paint your house is far from a simple, personal choice. It is a decision subject to the approval of city officials, all in the name of preserving what's known as the Santa Fe style. This style is defined by the city's Historic Style Ordinance, a set of regulations that requires all buildings within the historic district, and even those in many surrounding neighborhoods, to adhere to a specific architectural aesthetic. This primarily means using traditional building materials like adobe, stucco, and wood, but the rules extend with incredible precision to the very colors permitted on exterior walls. Homeowners aren't free to browse the entire spectrum at the paint store. Instead, they must select from a pre-approved palette of historically accurate, earth-toned colors. These are hues inspired by the surrounding landscape, various shades of tan, brown, pink, and sand, often described as terracotta, tan, rose, and ochre. The goal is to make buildings look as if they were crafted from the very earth they stand on, creating a harmonious and continuous visual experience throughout the city. So, what does this mean for someone who owns a home in Santa Fe? The process is more involved than you might think. Before a single brush stroke hits the wall, a homeowner must submit a formal application to the city's Historic Districts Review Board. This application includes detailed samples of the proposed paint colors. The board then evaluates whether those colors conform to the official palette and fit the specific context of the building's location and architecture. It's not a rubber stamp approval. Proposals can be, and often are, rejected for being too bright, too modern, or simply not in keeping with the adjacent structures. Choosing to skip this process and paint your house a bold, unapproved color like cobalt blue or sunshine yellow can lead to significant consequences, including substantial fines and a city order to repaint the entire property at your own expense. The rationale behind this strict control is deeply rooted in a desire to protect Santa Fe's unique identity and economic vitality. City planners and preservationists argue that the distinct visual character is not just about aesthetics, it's a crucial part of the city's brand. That uniform, earth-toned look is a major draw for the millions of tourists who visit each year, fueling the local economy. They see the ordinance as a necessary tool to prevent the kind of haphazard development that could dilute the very charm that makes Santa Fe so special. It's a philosophy that prioritizes the collective visual heritage of the community over individual expression. However, this approach inevitably sparks a fierce debate about the limits of property rights. For some homeowners, these regulations feel like an overreach, an infringement on their freedom to personalize their own investment. They ask a fundamental question: if you own a property, shouldn't you have the right to choose its color? Critics of the ordinance argue that while preserving history is important, the rules can be excessively rigid, stifling creativity and imposing a uniform blandness that suppresses individuality. This tension between individual liberty and communal standards is a battle being fought not just in Santa Fe, but in countless communities across the nation, making it a central theme in the weird world of American housing laws. But the clash between personal freedom and community standards is not only about aesthetics, it can also flare up around something as fundamental as keeping warm. This brings us to the famously foggy and often chilly city of San Francisco, where a different kind of regulation has sparked debate. In a move that might surprise those who romanticize the idea of a cozy fire on a cold night, San Francisco has implemented a ban on the installation of new wood-burning fireplaces in all new construction projects and in existing buildings undergoing major renovations. The reasoning behind this law is deeply rooted in the city's strong environmental ethos and a very practical concern for public health. While a crackling fire might seem natural, wood smoke is a significant source of air pollution, releasing fine particulate matter and other pollutants that can aggravate asthma, contribute to heart disease, and create hazy conditions. For a city like San Francisco, nestled in a bay basin where air pollution can sometimes become trapped, reducing these emissions became a public health priority. The ban is part of a broader effort to improve air quality for all residents, positioning the comfort of a wood fire as a luxury that comes at a cost to the community's well-being. This creates a particularly sharp irony for anyone who has experienced San Francisco's unique climate. The city is known for its damp, foggy summers where temperatures can plummet dramatically once the sun goes down, even in July and August. The idea of needing heat in the middle of summer is not at all unusual there. So, while the environmental reasoning is sound, the ban means that new homeowners or those remodeling their houses are forever shut off from that traditional form of warmth and ambience, precisely in a place where a chilly evening is a year-round possibility. Of course, this hasn't left residents out in the cold. The law has spurred innovation and adaptation, leading to a widespread embrace of alternative heating sources. Gas fireplaces have become the standard replacement, offering instant, controllable flames with significantly lower emissions. Many residents have also turned to electric fireplaces, which provide the visual appeal of a fire with no emissions at all, or have invested in highly efficient central heating systems. This shift highlights a larger trend in urban planning where individual habits are being reshaped by collective goals for cleaner air. It's a clear example of how a housing regulation can directly alter daily life, pushing technology and behavior in a new direction for the sake of the common good. While San Francisco's fireplace ban deals with communal health and environmental priorities, other regulations emerge from a far more personal and often contentious source: the simmering tensions between next-door neighbors. This brings us to a classic and peculiarly American housing dilemma, one so fraught with emotion that the state of Massachusetts felt compelled to write a specific law addressing it. Imagine a beautiful summer day and you decide to build a tall, solid fence around your backyard, seeking a little extra privacy. But if you live in Massachusetts and that fence exceeds 7 feet in height, your project could be legally declared a spite fence, and a judge could order you to tear the whole thing down. The concept of a spite fence might sound like something from a cartoon, but in legal terms, it is very real. Massachusetts General Laws, Chapter 49, Section 21, provides a clear definition. It states that any fence or other structure over 7 feet tall, which is unnecessarily high and is maliciously erected or maintained for the purpose of annoying a neighbor, can be deemed a private nuisance. The law doesn't mince words. It explicitly allows the affected neighbor to take the fence builder to court. If the court finds that the primary motive was indeed spite or malice, it can issue an injunction forcing the property owner to reduce the fence's height or remove it entirely. The 7-foot mark is the critical threshold. A 6'11" fence, while potentially annoying, does not fall under this specific statute, making that single inch a legally significant measurement. To understand why such a specific law exists, we have to look back to the late 19th century, a time of rapid industrialization and growing urban density. As cities grew, properties became smaller and neighbors lived in closer quarters. Disputes over property lines, noise, and views became increasingly common. The most famous case that inspired this legislation involved 2 wealthy Bostonians, Austin H. Merrill and his neighbor, A. Burridge. Their feud escalated to the point where Burridge constructed an enormous 50-foot tall wooden fence around Merrill's property, specifically designed to block his light and view. This colossal structure wasn't for privacy or security. It was a monumental act of pettiness, a physical manifestation of a bitter personal quarrel. The case captivated the public and highlighted a gap in the law: how to address a structure that was technically on someone's own property but was built with the sole intent of harming a neighbor. The Massachusetts legislature responded by creating the spite fence law in the 1880s, establishing a legal remedy for victims of such architectural aggression. Proving malicious intent in court, however, is the real challenge. A judge doesn't simply take one neighbor's word that the other is acting out of spite. The court looks for a pattern of evidence. Was there a recent, heated argument between the parties? Did the property owner choose a design that is unusually ugly or obstructs a particularly valuable view, like a scenic vista, when a simpler, less intrusive design would have served the same functional purpose? Did the builder make any verbal threats or admissions, perhaps boasting about the intention to block them out for good? The court essentially has to become a detective of human pettiness, weighing the facts to determine if the fence is a reasonable exercise of property rights or a weaponized structure. In one modern case, a homeowner was found to have built a fence specifically to block a neighbor's newly installed solar panels, which he had previously complained about. The combination of timing, his prior objections, and the fence's specific placement and height led the court to rule it was a spite fence. This law represents a fascinating balance in American property rights. The general principle is that you can do what you want on your own land, but that principle has limits when your actions are undertaken not for your own benefit, but specifically to cause harm to someone else. It acknowledges that while property ownership confers many rights, the right to torment your neighbor isn't one of them. The Massachusetts spite fence statute stands as a unique legal monument to the fact that sometimes the most bizarre housing rules aren't about paint colors or fireplaces, but about managing the complex and often surprisingly childish dynamics of human relationships. But the boundaries of property rights extend far beyond fences and into the very definition of who is allowed to live within a home. We now turn to one of the most pervasive and contentious housing regulations in America, a rule that doesn't govern paint, fences, or fireplaces, but rather the personal relationships of the people inside. In countless cities and towns across the country, it is technically illegal for more than 2, 3, or sometimes 4 unrelated adults to share a single-family home. These laws, often known as U2 ordinances or single-family zoning restrictions, legally define what constitutes a family, and that definition explicitly limits the number of people not related by blood, marriage, or adoption who can reside together under one roof. The origins of these ordinances are deeply tied to the expansion of higher education in the 20th century. As universities grew, so did the influx of students into surrounding residential neighborhoods. Homeowners began to complain about the changes they saw. Suddenly, a quiet house might be occupied by 5 or 6 students, leading to more cars on the street, louder social gatherings, and what long-term residents often perceived as a decline in property upkeep. In response, municipal governments crafted these laws as a tool to preserve the character of their neighborhoods. By legally restricting how many unrelated people could live together, they aimed to prevent houses from being converted into de facto dormitories or boarding houses, effectively keeping student populations contained to specific areas zoned for higher density. The underlying idea was that a traditional nuclear family, parents and their children, would naturally maintain a quieter, more stable, and more permanent presence than a rotating cast of roommates. This logic, however, creates a stark and legally sanctioned double standard. Under a typical U2 ordinance, a biological family of 10 two-parents and their 8 children can legally occupy a 3-bedroom house without any issue. The law sees them as a single family unit, but if 4 unrelated adults, say a nurse, a teacher, a graduate student, and a barista, attempt to rent that same 3-bedroom house to pool their resources and afford a better neighborhood, they would be in violation of the law. The number of people, cars, and potential for noise is identical, but the legal status of their personal relationships makes all the difference. This distinction is at the heart of the modern controversy surrounding these rules. Today, these ordinances are facing intense scrutiny and legal challenges on multiple fronts. The most pressing issue is the nationwide crisis of housing affordability. For many young adults, recent graduates, and low-income workers, sharing a home with roommates is not a lifestyle choice but an economic necessity. It is the only way to afford rent in many desirable cities with strong job markets. By artificially limiting the supply of shared housing, these laws drive up costs for everyone. They reduce the number of potential tenants for a property, which can discourage investment in rental units, and they force people into more expensive, smaller apartments or into long, costly commutes. Critics argue that in an era of skyrocketing housing prices, laws that prevent efficient use of the existing housing stock are profoundly counterproductive and exacerbate homelessness and economic inequality. Furthermore, these laws are increasingly seen as a form of systemic discrimination. While they may appear neutral on the surface, their impact falls disproportionately on certain groups. Young people, who are more likely to have roommates before starting families, are directly targeted. Immigrant communities, where it is common for extended networks of friends or distant relatives to live together for mutual support, can also be unfairly penalized. The ordinances have also been used to break up group homes for adults with disabilities or people in recovery programs, groups that rely on communal living for care and stability. Because of this, many legal challenges assert that these laws violate the Fair Housing Act by having a discriminatory effect, even if that wasn't the original intent. The battle over these ordinances is a microcosm of a much larger struggle over the future of American communities. On one side are those who value stability, quiet, and a particular vision of neighborhood life, often rooted in a mid-century ideal of the single-family home. On the other side are those who argue for inclusivity, affordability, and the right to choose one's own living arrangements without government interference based on personal relationships. As cities grapple with changing demographics and economic pressures, the definition of a family in the eyes of the law is being forced to evolve, challenging a regulation that, for decades, has quietly dictated who gets to live where. While the debate over who can live in a house is a major issue impacting millions, sometimes the strangest housing laws are not about who is inside, but where they are choosing to sleep. This brings us to a statute that seems almost too peculiar to be real, found in the state of Illinois. Tucked away in the legal code is a provision that makes it a criminal offense for any person to sleep in a doghouse, a poultry house, or any other structure that was erected for the confinement of animals. Just let that sink in for a moment. A law exists with the full force of the state behind it, specifically forbidding you from bedding down in a doghouse. The immediate and obvious question is, what kind of situation could have possibly prompted legislators to take the time to draft, debate, and pass such a bizarrely specific rule? Laws like this are rarely born from abstract theory. They are almost always a direct reaction to a specific, and likely very strange, event. We can only speculate, but it's not difficult to imagine the scenario that might have led to this. Picture a cold night in a small Illinois town, perhaps decades ago. A local resident, maybe after a particularly heated argument with a spouse or having had one too many at the town tavern, stumbles into the backyard and decides the family dog's house looks like a reasonable place to spend the night. A neighbor sees this, is sufficiently alarmed or annoyed, and calls the authorities. The police arrive to find an adult human crammed into a small wooden structure intended for a German shepherd. Without a specific law on the books, what exactly is the charge? Trespassing doesn't apply if it's their own yard. Public drunkenness might be a stretch if they're on private property. The incident likely created a legal quandary, leading a determined prosecutor or a bemused lawmaker to decide that the statutes needed an update to cover this very specific form of unconventional lodging. The law effectively closes a loophole, ensuring that next time there is a clear violation to cite. This Illinois statute is a perfect example of what legal scholars often call an odd or archaic law. These are regulations that remain on the books long after their original purpose has faded from memory, serving as quirky reminders of a different time. They often address a problem that was so unique or so irritating to a community that it required a legislative solution, but which seems utterly nonsensical to us today. The law against sleeping in a doghouse is part of a much broader category of regulations governing human habitation in non-standard dwellings, many of which were created with a mixture of genuine safety concerns and a heavy dose of social control. Throughout American history, there has been a persistent effort by governments to define and enforce what constitutes acceptable housing, often targeting the poorest and most vulnerable populations. In the late 19th and early 20th centuries, as industrial cities swelled with new residents, countless people were forced to live in squalid and desperate conditions, in cellars, attics, and even stables. In response, cities began to enact building codes and occupancy standards aimed at improving public health and safety. These were well-intentioned laws against genuine hazards like fire traps and structures with no sanitation. However, they were often applied in a way that also targeted alternative lifestyles and economic necessity. For instance, many places had laws specifically against living in a vehicle or a tent on your own property, rules designed to prevent the emergence of shanty towns or Hoovervilles during the Great Depression, but which also criminalized poverty itself. The Illinois doghouse law, in its own peculiar way, fits into this pattern. While it might seem laughable today, it likely stemmed from a desire to maintain a certain standard of living and to discourage what was seen as indecent or degrading behavior. It draws a very clear legal line in the sand about what is a fit place for a human being to reside. This impulse to legislate normality can be seen in other surviving laws, such as ordinances that prohibit using a camper or RV as a permanent residence in a residential driveway, or old laws in some desert towns that made it illegal to live in a cave. These rules reveal a deep-seated cultural belief that proper citizens live in proper houses, and any deviation from that norm is suspect and potentially illegal. What makes the doghouse law so fascinating is its incredible specificity. It doesn't just say you can't live in an unfit dwelling, it names the exact type of unfit dwelling, showcasing a legislative mindset that felt the need to cover every conceivable base. In the modern era, such a law is almost certainly unenforced, a legal relic that would be dismissed by any reasonable court. But its continued existence on the books is a testament to the fact that our legal landscape is not a perfectly pruned garden, but a forest where ancient, gnarled trees of forgotten statutes still stand, waiting for someone to point a camera at them and ask, what were they thinking? Moving from laws that dictate where you can sleep to those that govern what you can sell, our tour of peculiar property rules takes us to the seemingly innocent world of the garage sale. For many, holding a yard sale is a quintessential part of American life, a weekend ritual of decluttering, making a few extra dollars, and chatting with neighbors. But in numerous towns across Connecticut, this simple activity is strictly regulated, with laws that limit how often you can hold a sale and even require you to obtain a permit from the local government. It's a system that transforms a casual Saturday morning event into a legally sanctioned occasion. The specific rules can vary from one municipality to another, but they often follow a similar pattern. A typical ordinance might restrict a homeowner to holding no more than 2 or 3 garage sales per calendar year. Each sale is usually limited to a set number of consecutive days, often 2 or 3. Crucially, before you can so much as hang a single brightly colored sign on a telephone pole, you are required to apply for and receive a permit from your town hall, for which there is usually a small fee. The application process itself can be detailed, asking for the exact dates of the sale and even a list of the primary items to be sold. These regulations are designed to draw a very clear legal line between an occasional, non-commercial event and a recurring business operation. So, what is the reasoning behind turning a garage sale into a permitted activity? Town officials and zoning boards argue that these laws are essential for maintaining the character and safety of residential neighborhoods. The primary intention is to prevent homeowners from effectively running a permanent retail business out of their garage or driveway. Without these restrictions, a resident could theoretically hold a sale every single weekend, turning their quiet home into a constant destination for traffic, with cars clogging the street, strangers coming and going at all hours, and noise disrupting the peace of the community. This could also lead to issues with parking, litter, and even security concerns. By limiting the frequency, the law aims to preserve the primarily residential nature of the area, ensuring that one person's entrepreneurial spirit doesn't negatively impact their neighbor's quality of life. There's also an economic dimension to these regulations. Cities and towns rely on tax revenue from commercial businesses operating in properly zoned areas. If someone were to run a continuous retail operation from their home, they would be competing with brick and mortar stores that pay commercial property taxes, business licenses, and collect sales tax. The garage sale permit system helps uphold the integrity of local zoning laws, which deliberately separate residential and commercial activities. It's a way of ensuring a level playing field for established businesses that follow the rules and contribute to the municipal tax base. Enforcement of these laws often falls to a town's zoning enforcement officer or even the police department, and it is frequently complaint-driven. A neighbor who grows tired of the constant stream of cars and customers next door might file a formal complaint, triggering an investigation. The consequences for violating these ordinances can include fines, and repeat offenders could face steeper penalties or even a court order to cease all sales activity. For most residents, these rules are simply a minor bureaucratic hurdle, a quick trip to town hall that is part of the planning process. But they also create an interesting dynamic within communities where the simple act of selling old possessions requires a conscious awareness of the law and a consideration for how one's actions affect the entire neighborhood. This delicate balance between individual freedom and communal harmony is a recurring theme, proving that even the most humble of domestic activities can be subject to the complex web of American housing regulations. Yet perhaps one of the most relatable and quietly controversial regulations involves a simple, age-old practice, hanging your laundry out to dry in the sun. In countless suburban communities across the United States, governed by homeowners associations or specific municipal codes, the humble clothesline is not seen as a symbol of thrift or sustainability, but as an eyesore, an aesthetic blight strictly prohibited by covenant. These bans are often justified under broad rules that forbid any unsightly objects in yards, placing a simple rotating T-post and a line of flapping towels in the same category as a rusted car on blocks. The logic from the perspective of an HOA board is rooted in a very specific vision of suburban perfection: uniform, manicured lawns where the only movement is a sprinkler and the only visual elements are approved landscaping. To them, a clothesline represents disorder. It introduces the mundane reality of domestic chores into the curated public view of the neighborhood. The flapping sheets and shirts are seen as a sign of poverty or a lack of modern convenience, potentially lowering the perceived property values of the entire community by suggesting that residents cannot afford electric dryers. This desire for visual control is so powerful that it has led to fines for homeowners and even legal threats for something as simple as draping a wet beach towel over a porch railing. But this push for aesthetic conformity has sparked a powerful and growing counter-movement known as the Right to Dry movement. What began as scattered acts of civil disobedience, homeowners quietly stringing up lines in their backyards, has evolved into a coordinated effort to reframe the issue not as one of mere personal preference, but of fundamental rights and environmental responsibility. Advocates argue that using the sun and wind to dry clothing is a form of harnessing solar energy, a clean, free, and infinitely renewable resource. They point out the staggering energy consumption of tumble dryers, which are among the most power-hungry appliances in a typical home, and question the logic of banning a zero-emission alternative in an era of climate change. This compelling argument has led to significant legislative victories. States like Florida, Colorado, Utah, and Hawaii have passed laws that explicitly protect a homeowner's right to use a clothesline, nullifying any HOA covenants that attempt to ban them. These solar access or right to dry laws acknowledge that the individual's interest in energy conservation and lower utility bills outweighs an association's desire for strict aesthetic control. The laws often include specific provisions. For example, they may prevent HOAs from banning lines in fenced-in backyards, though they might allow for reasonable restrictions on their placement in front yards to find a middle ground. The clash over the clothesline is a perfect microcosm of a much larger cultural shift. It represents a conflict between a 20th century ideal of suburban uniformity and a 21st century imperative for sustainable living. It pits the power of private contracts, which homeowners voluntarily agree to when they move into an HOA, against a growing public interest in reducing our collective carbon footprint. For the individual homeowner, it becomes a deeply personal choice. Is the convenience of a dryer worth the financial and environmental cost? And do you have the right to make that choice for yourself? The sight of a clothesline billowing in the breeze is no longer just about dry laundry. It has become a silent, powerful statement about independence, common sense, and the right to live a little more gently on the planet. And if you thought a clothesline ban was a peculiar battle between personal choice and public perception, wait until you hear about the law that takes this conflict to a whole new level of absurdity, especially given its location. We're heading to the sun-scorched city of Tucson, Arizona, a place better known for its towering saguaro cacti and blistering summer heat than for any concerns about winter weather. Yet, buried within Tucson's city code is a regulation that seems almost like a punchline. It is technically illegal to build a snowman on a public street or sidewalk. The sheer improbability of this law is what makes it so instantly captivating. Tucson averages only about 1 inch of precipitation for the entire month of December, and measurable snowfall is an exceptionally rare event, happening perhaps once every few years. On those miraculous occasions when a few flurries do manage to dust the desert landscape, it's cause for city-wide celebration. Children, and more than a few adults, rush outside to experience the novelty. But according to the letter of the law, if any of those excited residents were to gather up the precious, slushy snow and pile it into a frosty figure on a public right-of-way, they would be committing a misdemeanor. The law is likely part of a broader ordinance aimed at preventing any obstructions on public pathways, grouping a lovingly crafted snowman in the same legal category as an abandoned couch or an unpermitted lemonade stand, deemed a hazard to pedestrians and traffic. This is where we find the classic disconnect between the practical intent of a law and its hilarious real-world application. The practical reason is almost certainly rooted in public safety. A snowman, even a modest one, does take up space. Placed on a narrow sidewalk, it could force a person using a wheelchair into the street. Built too close to a curb, it might obscure the line of sight for a driver at an intersection. The law was almost certainly written by a city attorney thinking generically about encumbrances or obstructions, using broad language meant to cover a wide range of potential problems, from construction debris to overgrown hedges. The fact that this language could be applied to a snowman in a desert is a beautiful example of a legal gray area, a rule created for a common problem in one part of the country becoming an almost mythical statute in another. Laws like Tuckson's snowman ban are perfect examples of what are often called zombie laws, statutes that remain on the books long after their relevance has faded, or that were so narrowly targeted they rarely, if ever, see enforcement. They are the legal equivalent of an appendix, a vestigial part of the civic body that doesn't really serve a purpose, but hasn't caused enough trouble to be removed. The cost and effort of reviewing and repealing every single outdated law is significant, so unless one causes a genuine problem, it often just sits there, a curious relic waiting to be discovered. It's highly doubtful that the Tucson Police Department has a special snowman patrol on standby for those biannual snowy days. In the incredibly unlikely event that someone were ticketed, a judge would almost certainly dismiss the case as an unreasonable application of the law. The spirit of the law in this case would clearly outweigh its literal and quite silly interpretation. These zombie laws exist in nearly every municipality, serving as humorous reminders that our legal system is not a perfectly curated collection of rules, but rather a sprawling, often messy, accumulation of responses to problems both real and imagined. They highlight the inherent challenge of governance, crafting laws that are specific enough to be effective but broad enough to be practical, all while trying to anticipate every conceivable scenario, even the prospect of a snowman in the desert. They are less about active control and more about a system's inability to constantly clean its own attic, leaving behind artifacts that tell a strangely charming story about the times and concerns that created them. But the regulation of our homes doesn't stop at the walls or the fence line. It extends right down to the very blades of grass beneath our feet. Perhaps the most common and widely encountered of all America's peculiar housing rules is the humble lawn grass ordinance. In thousands of towns and cities, from sprawling suburbs to small rural communities, there exists a local law specifying the exact maximum height your lawn is legally allowed to reach. Letting your grass grow wild isn't just a matter of personal preference or a sign of a busy schedule. It can be a violation of city code, punishable by a fine that increases with every day you remain out of compliance. This is the government, quite literally, telling you to mow your lawn. The justifications for these ordinances are typically grounded in public health and community welfare. The most frequently cited reason is pest control. Tall grass and overgrown weeds provide an ideal habitat for unwanted visitors like rats, mice, snakes, and ticks. By mandating a trimmed lawn, the city aims to reduce these potential public health hazards, creating a buffer zone that discourages vermin from taking up residence close to homes. Another common argument revolves around fire safety. In drier climates, a field of tall, dead grass adjacent to a house is a significant fire risk, a tinderbox waiting for a single spark. Keeping lawns short reduces this danger. Then there is the matter of pure aesthetics. Municipal governments argue that unkempt properties drag down the visual appeal of an entire neighborhood, which can, in theory, lower property values for everyone. A well-maintained street, they reason, signals a caring, stable community, and the lawn is the most visible indicator of that care. Enforcement, however, is where these well-intentioned rules often spiral into absurdity and acrimony. Typically, the process is complaint-driven. One neighbor, annoyed by the state of the yard next door, files a complaint with the city's code enforcement office. An officer is then dispatched to investigate. This is where the specificity of the law comes into play. The ordinance won't just say, "Keep your grass short." It will specify a precise measurement, often something like 6, 8, or 10 inches. The enforcement officer doesn't just eyeball it. They may literally get out a ruler and measure. If the grass exceeds the limit, the homeowner receives a formal notice, giving them a short window, perhaps 72 hours or a week, to rectify the situation. If they fail to do so, the city can levy a fine, and if the fines go unpaid, the city can eventually place a lien on the property, meaning a few inches of overgrown fescue could theoretically put your home at risk. This system creates a perfect breeding ground for neighborly conflict. What might start as a simple disagreement over landscaping can escalate into a full-blown feud, fought not with shouting over the fence, but with official city paperwork. There are countless stories of homeowners going on vacation and returning to find hundreds of dollars in fines because their grass grew half an inch past the limit while they were away. Others involve disputes where one neighbor maliciously reports another repeatedly out of sheer spite, forcing them to constantly defend their property against city inspectors. In one infamous case in Dunedin, Florida, a man was threatened with fines of up to $500 a day because his lawn, which he had intentionally turned into a wildflower meadow to support pollinators like bees and butterflies, violated the city's turf grass height ordinance. His argument that his yard was an environmentally friendly habitat fell on deaf ears at the Code Enforcement Board, highlighting the clash between traditional notions of neatness and modern ecological values. The ultimate escalation of this enforcement power reveals a startling reality. In many jurisdictions, if a homeowner refuses to mow their lawn, the city government has the legal authority to do it for them. They will hire a landscaping crew, send them onto the property to cut the grass, and then bill the homeowner for the service. If the bill isn't paid, it becomes a lien on the house. This practice, known as abatement, turns the local government into a forced landscaping service with the power to enter your property and alter it, then charge you for the privilege. While this is reserved for extreme cases of neglect, it underscores a profound principle. When it comes to your lawn, the community's standards can legally trump your individual liberty. The battle over grass height is a quiet, everyday reminder that your little patch of land is not entirely a kingdom unto itself. It is part of a larger community, bound by rules that dictate even the most mundane aspects of its appearance. Now, just when you thought housing laws couldn't get any more personal, consider a regulation that ventures beyond your lawn and into the most private room of your home, the bathroom. An obscure statute from the state of Ohio takes the concept of controlling property use to an entirely new level of intimacy. This law, which has managed to linger on the books for decades, makes it illegal for a homeowner to allow a person of the opposite sex to use their bathroom if the home contains only one bathroom, unless, of course, the two individuals are married or directly related by blood or marriage. To understand how such a specific and invasive rule came to exist, we have to travel back to a very different era in American social history. This law is a direct relic of the late 19th and early 20th centuries, a time defined by rigid Victorian social codes and a powerful movement often referred to as purity crusading. During this period, there was a widespread cultural anxiety about morality, particularly concerning the interactions between unmarried men and women. The fear was that any situation allowing for privacy or the mere appearance of impropriety could lead to scandalous behavior or the erosion of public morals. These concerns were especially pronounced in rural areas and small towns where community scrutiny was intense and social standing was paramount. Legislators, aiming to legislate morality and uphold what they saw as public decency, crafted laws that attempted to dictate private conduct in semi-public spaces, including rooming houses and private residences that took in boarders. The single bathroom rule was likely intended to prevent any possibility of unwanted encounters or the suggestion of illicit activity under a homeowner's roof, effectively making the property owner legally responsible for enforcing a strict moral code. The practical application of this law in the modern era is, to put it mildly, almost unimaginable. Think about the common scenarios it would criminalize. A female homeowner having her brother-in-law over for a holiday dinner would be perfectly within the law to allow him to use the facilities. But if she had a male coworker over to work on a project and that coworker needed to use the solitary bathroom, they would both technically be violating the statute. A man living in a one-bathroom apartment could host his sister without issue, but if a female friend stopped by for a visit, the simple, biological need to use the restroom would transform a social call into a misdemeanor. The law creates an absurd distinction where the legality of a basic human function is determined not by necessity, but by the specific familial or marital relationship between two people. It is crucial to note that this law is almost certainly unenforced today, a classic example of a dead-letter statute. No police department in Ohio is actively conducting bathroom stakeouts or responding to complaints about unauthorized lavatory use. If a case were ever brought to court, it would almost certainly be dismissed as a violation of modern notions of privacy and an unconstitutional intrusion into personal liberty. The law remains on the books not because it reflects current values, but because the process of reviewing and repealing every outdated law is a massive undertaking, and such obscure rules are usually only discovered and removed when they accidentally cause a problem or a curious journalist brings them to light. Yet, the continued existence of this peculiar regulation serves as a fascinating historical artifact. It is a tangible reminder of a time when the government saw fit to embed its puritanical moral compass directly into the framework of housing law, attempting to regulate the most minute details of personal life. It highlights a persistent tension in American jurisprudence, the often blurry line between protecting public welfare and infringing upon private autonomy. While we may laugh at the absurdity of an unenforceable bathroom law, it prompts a deeper reflection on the laws we are creating today. Future generations may look back on some of our current housing regulations with the same bewildered amusement, wondering what societal anxieties prompted us to write such specific and controlling rules into the legal code that governs the places we call home. But perhaps no entity embodies the strange and sprawling world of American housing regulations more powerfully than the Homeowners Association, or HOA. These private organizations, governing everything from massive planned communities to small condominium complexes, possess an authority that can feel almost governmental in its scope, yet they operate largely outside the direct oversight of public elections. When you purchase a home within an HOA's jurisdiction, you are not just buying property. You are entering into a binding contract, agreeing to abide by a dense set of rules known as covenants, conditions, and restrictions, or CC and Rs. This contractual agreement grants the HOA board the power to regulate an astonishing array of details about your daily life, transforming the concept of my home, my castle into my home according to the rules. The range of items subject to HOA control is breathtakingly comprehensive. It often begins with the architectural. You might need approval to install a new screen door, replace your windows, or even plant a tree. The rules can specify the exact style and color of your mailbox, the type of fencing permitted, and whether you can have a satellite dish, and if so, where it must be placed so as to be invisible from the street. But the control extends far beyond the structure itself and into the realm of lifestyle. Many HOAs have strict regulations on vehicles, prohibiting the parking of commercial trucks, boats, or even certain types of pickup trucks in driveways overnight, deeming them unsightly. Some have gone so far as to ban specific dog breeds perceived as aggressive, regardless of an individual dog's temperament. The temporal aspect of life is also managed. Rules frequently dictate how long after a holiday your decorations must be taken down, with fines accruing for every day a forgotten inflatable snowman remains on your lawn past January 5th. The enforcement mechanism for these rules is the fine system. Violating a covenant, whether intentionally or by accident, typically results in a formal notice and a monetary penalty. These fines can start small, perhaps $25 or $50 for a first offense, but they can escalate rapidly for repeat violations or for non-compliance. If a homeowner refuses to pay or refuses to correct the violation, the HOA can take increasingly severe actions. They can place a lien on the property which can prevent its sale, and in extreme cases, they can even foreclose on the home, forcing a sale to collect the unpaid fines and legal fees. This immense power, wielded by a voluntary board of neighbors, is what makes conflicts with HOAs so notoriously bitter and high stakes. A dispute over something as seemingly minor as a basketball hoop left at the curb can spiral into a financial crisis for a family. Examples of particularly bizarre or heavy-handed HOA rules are legion and have become the stuff of news headlines and legal battles. One association in Texas made national news for demanding a family take down their children's playhouse because it violated rules against permanent auxiliary structures, despite the playhouse being a simple, movable wooden design. Another HOA in Florida threatened a family with fines for flying an American flag on a flagpole that was not approved by the Architectural Committee, a controversy that eventually led to a state law protecting the right to fly the flag. There are countless stories of associations regulating the shades of beige. A house can be painted with a specificity that would impress a museum curator, or banning laundry from being dried on a discreet backyard clothesline, as we discussed earlier. The fundamental tension at the heart of the HOA phenomenon is the trade-off between uniformity and freedom. Proponents argue that these strict rules are precisely what protect property values. By ensuring that every home in the community meets a high standard of maintenance and appearance, and by preventing any one homeowner from engaging in behavior that could be deemed disruptive or unattractive, the HOA creates a stable, predictable, and desirable neighborhood. For many people, this assurance of conformity is a feature, not a bug. It's why they choose to buy in an HOA community in the first place. They are paying for the guarantee that their neighbor won't paint their house neon green or park a junk car on the lawn. Critics, however, see this system as a recipe for the abuse of power and the suppression of individuality. They argue that HOAs often attract board members who are overzealous or who use the rules to settle personal grudges with their neighbors. The very nature of the covenants can be inflexible, failing to account for changing lifestyles or cultural norms. The ultimate question becomes, does the collective good of maintained property values justify the level of control over an individual's private life? For those living under the rule of an HOA, the answer can change with every notice left in the mailbox, a constant reminder that in the world of American housing, the concept of ownership is often a shared proposition. This push and pull between individual property rights and community regulation reaches its most modern and perhaps most poignant expression in the growing movement toward tiny homes. On the surface, the appeal is undeniable: a lifestyle of radical simplicity, financial freedom, and a smaller environmental footprint. But for those who attempt to make this dream a reality, they quickly discover that the American legal system is overwhelmingly designed for a different way of life, one centered on traditional, large-scale housing. The tiny home, for all its charm and efficiency, often exists in a bewildering legal gray area, a no-man's land between the definitions of a permanent house and a temporary vehicle. The first and most significant hurdle is the very definition of a dwelling. Most local building codes, which have been developed over decades, include something called a minimum square footage requirement for a single-family home. These requirements were originally established to ensure basic standards of health and safety, preventing the kind of overcrowded and substandard slum housing seen in the past. However, these minimums now pose an almost insurmountable barrier to tiny homes. It's not uncommon for a municipal code to mandate that a new dwelling must be at least 1,000 square feet, with some areas requiring even more. A typical tiny house, which might be a perfectly comfortable 400 square feet, is automatically illegal to build on a foundation in these jurisdictions simply because it is too small. The law, in its effort to prevent inadequacy, effectively outlaws innovation and efficiency. This forces many tiny home enthusiasts to classify their homes as recreational vehicles, or RVs. This seems like a logical workaround. Many tiny homes are built on trailers for mobility, but this classification creates a whole new set of problems. If a structure is legally an RV, it is not meant for permanent, year-round residence. Most zoning laws strictly prohibit people from living full-time in an RV parked on their own property, or even in a dedicated RV park. These laws are intended to prevent the emergence of makeshift trailer parks and to maintain the character of residential neighborhoods. So a person could build a beautifully crafted, fully insulated tiny home on wheels, only to be told they cannot legally live in it on any piece of land they own because it's considered a vehicle, not a house. They are caught in a catch-22. Their home is too small to be a house, but too house-like to be an acceptable vehicle for permanent living. Beyond size and classification, there's the intricate web of utility connection mandates. Building codes for permanent dwellings almost universally require a home to be connected to municipal sewer and water systems, or to have a professionally engineered and approved septic system and well. For a tiny home that aims for off-grid independence using composting toilets and rainwater collection, these requirements can be a deal breaker. Health departments view these alternative systems with skepticism, concerned about potential contamination and public health risks, even when the technology is proven and safe. The legal framework simply hasn't caught up to allow for sanctioned, sustainable off-grid living, forcing many tiny home dwellers into a precarious position of being technically in violation of health codes. Despite these pervasive challenges, a growing number of towns and cities are beginning to see tiny homes not as a problem, but as a potential solution. They are recognizing that these small dwellings can be a powerful tool for addressing acute housing shortages, especially for key workers like teachers and nurses who are priced out of expensive markets. Some progressive communities have created specific zoning allowances for tiny home villages or accessory dwelling units, often called ADIUS or granny flats. For instance, the town of Spur, Texas, made national headlines by declaring itself the first tiny house-friendly town in America, actively rewriting its ordinances to welcome tiny homes on permanent foundations. Similarly, Fresno, California, took a bold step by allowing tiny homes on wheels to be permitted as backyard cottages if they meet certain aesthetic and safety standards, providing a legal pathway for homeowners to add rental income or housing for family members. On the other end of the spectrum, many municipalities remain firmly opposed, enacting explicit bans that leave no room for ambiguity. The reasons for opposition often echo the same concerns we've seen with other housing regulations: fears about declining property values, worries that tiny home communities will strain public services, and a deep-seated attachment to the traditional aesthetic of suburban life. The battle over tiny homes is therefore a microcosm of a larger cultural debate about what constitutes a good neighborhood and who gets to decide. It pits a desire for affordability, sustainability, and personal freedom against a powerful preference for stability, conformity, and established norms. For every town like Spur that rolls out the welcome mat, there are countless others where the tiny home dream is stifled by codes written for a different century, leaving pioneers in a frustrating fight to find a legal place to simply call home. While the battle over tiny homes highlights a struggle to fit new forms of housing into old legal frameworks, other regulations focus on a far more traditional boundary marker: the fence. And when it comes to fences, few materials are as symbolically charged as barbed wire. Often associated with securing vast ranches or high-security industrial sites, the idea of barbed wire in a typical suburban neighborhood seems jarring, even aggressive. That's precisely why many cities and states heavily restrict or outright ban its use in residential areas. But the state of Florida approaches this issue with a characteristically pragmatic twist, carving out a very specific and somewhat counterintuitive exception in its laws. Generally, Florida Statute 821.08 does prohibit the use of barbed wire for fencing in most urban and suburban settings. The primary concern is public safety. A standard barbed wire fence at 4 or 5 feet tall poses a significant risk of injury to children who might accidentally run into it, to pets that could get tangled, and even to adults who might brush against its sharp points. It's seen as an unnecessarily hazardous material for a community setting where people are expected to live in close proximity. However, the law doesn't stop at a simple ban. It goes on to state that this prohibition does not apply if the barbed wire is used as part of a fence that is at least 7 feet high, or if it is used primarily for agricultural purposes to contain livestock. The logic behind this 7-foot exception is fascinating, At that height, the dangerous barbs are positioned well above the head level of an average person, effectively removing the everyday risk of accidental contact. A fence that tall is no longer a simple property boundary, it is a serious security barrier. The law implicitly acknowledges that if a property owner has a legitimate need for that level of security, perhaps for a commercial warehouse, a junkyard, or even a secluded estate, the public safety argument becomes less compelling because the hazard is no longer readily accessible to a casual passerby. The agricultural exception is more straightforward. On a working farm or ranch, barbed wire is a standard, practical tool for managing cattle and other animals, and its use is accepted as a necessary part of rural life. This creates a unique balance between individual security concerns and communal well-being. A homeowner in a suburban Florida subdivision cannot ring their quarter-acre lot with a low-strung barbed wire fence to keep out trespassers, as the community's interest in safety outweighs that individual's desire for a prickly deterrent. However, that same individual, if they owned a large, rural property, could legally use barbed wire to secure their land. The law essentially draws a line, both literally and figuratively, based on the context of the property and the scale of the installation. It's a compromise that attempts to accommodate different needs without applying a one-size-fits-all rule. This approach stands in stark contrast to the laws in many other states and municipalities, which often impose absolute bans on barbed wire in any residential zone, regardless of height. In some communities, particularly those with strict homeowners associations, even the suggestion of barbed wire would be unthinkable, dismissed as antithetical to the desired aesthetic of a friendly, welcoming neighborhood. These outright bans prioritize a uniform visual character and a guaranteed level of safety above all else, leaving no room for exceptions. The Florida statute, by comparison, reflects a more nuanced understanding that property needs can vary dramatically from the dense streets of Miami to the sprawling cattle ranches of the interior, and that the law should be flexible enough to account for that diversity. This single regulation, focused on the specific height of a fence and the purpose of the land, encapsulates the ongoing negotiation in American housing law between the right to protect one's property and the responsibility to ensure the safety of the community. Perhaps the most ironic of all American housing regulations are those that govern what you can grow in the very soil you own, leading us to the surprising battle over the front yard vegetable garden. In numerous suburban towns and deed-restricted communities across the country, homeowners have been ordered by local governments or homeowners associations to rip out their tomatoes, lettuce, and zucchini, not because the plants are dangerous, but because they are considered unsightly. These rules often classify a productive vegetable patch as an unapproved landscaping feature or a non-conforming use, arguing that it disrupts the uniform, ornamental aesthetic that defines the neighborhood. The logic is that while a manicured lawn of Kentucky bluegrass is desirable, a plot of earth-yielding food for the table is a visual blight that supposedly threatens property values. The enforcement of these bans can feel both arbitrary and deeply personal. For the homeowner who has invested time and effort into cultivating their garden, receiving a violation notice can be baffling. The criteria for what constitutes an unacceptable garden are often vague, hinging on subjective terms like messy or unattractive. A perfectly maintained raised bed might be deemed a violation simply because it contains edible plants rather than decorative shrubs. In one particularly infamous case in Oak Park, Michigan, a resident named Julie Bass found herself facing misdemeanor charges, punishable by up to 93 days in jail, for replacing her water-intensive lawn with a resourceful vegetable garden. The city's argument was that her front yard was not suitably landscaped, with officials insisting that only grass or perhaps ornamental plants met the legal definition. Her case sparked national outrage, highlighting the absurdity of a system that could potentially jail a person for growing food. This clash is about far more than gardening preferences. It strikes at the heart of two competing visions of what a yard should be. On one side is the 20th century ideal of the suburban lawn, a green, carpet-like status symbol that signifies leisure, conformity, and control over nature. This model, heavily promoted after World War II, equated a weed-free lawn with good citizenship and a stable community. On the other side is a 21st century ethos that values sustainability, self-sufficiency, and ecological responsibility. For advocates of this view, a front yard vegetable garden is a powerful statement. It reduces water consumption, cuts down on the carbon footprint associated with transporting food, provides healthy, hyper-local produce, and supports pollinators. It transforms a sterile, decorative space into a productive, living ecosystem. The homeowners who challenge these ordinances often frame their fight not just as a property rights issue, but as a matter of food sovereignty, the right of people to have control over their own food systems. They ask a fundamental question in an era of concerns about food security and environmental sustainability: why should it be illegal to use one's own land to produce healthy food? This argument has gained significant traction, leading to a growing movement to pass right to garden laws at the state level. States like Florida and Illinois have enacted legislation that explicitly protects a homeowner's right to grow vegetables on their property, effectively voiding any local bans. These laws represent a significant shift, acknowledging that the individual and societal benefits of home gardening outweigh rigid aesthetic controls. Yet, the opposition from municipalities and HOAs remains steadfast, rooted in a genuine fear that non-conforming properties will drag down the value of every home on the street. The concern is that a vegetable garden could be perceived as a sign of poverty or neglect, signaling to potential buyers that the neighborhood is less prestigious. This argument, however, is increasingly challenged by reality. Studies and real estate trends are beginning to show that well-maintained, attractive edible landscaping can actually enhance curb appeal and property value, reflecting a growing consumer desire for sustainable and wholesome living. The battle over the front yard garden is ultimately a cultural negotiation, a slow-motion shift in which the symbolic power of the perfect lawn is gradually being overturned by the practical and ethical imperatives of growing our own food. Now, if you thought regulating your lawn or your garden was a sign of extreme control, wait until you hear about a rule that takes specificity to a whole new level: the mandatory mailbox. In certain towns across New Jersey, your mailbox is far from a personal choice. It is a civic accessory subject to ordinances that dictate its exact style, dimensions, material, and even its precise placement relative to the curb. This isn't a suggestion from a fussy homeowners association. It's municipal law, and violating it can lead to fines and orders to replace your non-conforming mailbox at your own expense. The reasoning behind these hyper-specific regulations is typically twofold, blending practicality with a strong dose of aesthetics. On the practical side, the United States Postal Service has clear operational guidelines for mail delivery. They need boxes to be at a certain height and distance from the road to allow carriers to efficiently deliver mail from their vehicles without having to dismount. A mailbox that is too low, too high, or set too far back forces the carrier to spend extra time, slowing down the entire route. By codifying these USP's recommendations into local law, towns can ensure a smooth, efficient mail service for every resident. If one homeowner's awkwardly placed box disrupts the flow, it becomes a community-wide issue, but the rules often go far beyond mere functionality, venturing deep into the realm of visual conformity. Many towns, particularly upscale communities and planned developments, have adopted what are known as master mailbox programs. Under these programs, there is often only one or two officially approved mailbox models that residents are permitted to install. You can't just go to a hardware store and pick any design you like. You must purchase the specific town-sanctioned mailbox, which is often a particular color, made from a certain material like black wrought iron or white powder-coated aluminum, and may even feature a standard house number plaque. The goal is to create a streetscape of perfect uniformity, where every mailbox is a matching bookend, contributing to a clean, orderly, and cohesive appearance that town planners argue enhances property values and community pride. For a new homeowner moving into such a town, the process can be surprisingly bureaucratic. Before you can even receive mail, you may need to ensure your mailbox complies with the local code. This might involve submitting a permit application to the Public Works Department or having a town inspector come out to verify that the box is the correct model, is planted at the mandated height of between 41 and 45 inches from the road surface, and is set back exactly 6 to 8 inches from the face of the curb. If your predecessor installed a charming, rustic wooden box or a quirky custom design, you could be held responsible for replacing it with the standard issue model. The enforcement is often strict. Non-compliant mailboxes may not receive mail delivery until they are brought up to code, and homeowners can face recurring fines until the situation is corrected. This level of control over such a minor property detail exemplifies a fascinating philosophical divide. Proponents see it as the ultimate expression of a well-managed community, where even the smallest elements are curated for the collective good. They argue that this attention to detail is what separates their town from others, creating an environment of excellence and stability that benefits everyone. Critics, however, see it as municipal overreach at its most absurd, a symbol of how government can intrude into the most mundane aspects of daily life. They question why the town should have a say in the design of a mailbox, an object that is, for all intents and purposes, a federal instrument for receiving mail. The battle over the mailbox becomes a microcosm of a larger debate about the boundaries of community standards and individual expression, proving that in the weird world of American housing laws, even the humble act of checking your mail is a regulated experience. Yet another dimension of American housing regulation reveals itself not in rules about what you can do to a house, but in laws that targeted the very form and design of the house itself. This brings us to the history of the shotgun house, a distinct architectural style deeply rooted in the American South, and the deliberate, often racially charged efforts to legislate it out of existence. The classic shotgun house is a study in efficient design, a long, narrow structure, typically just one room wide and 3 or 4 rooms deep, with each room opening directly into the next, often without a hallway. The name itself is said to come from the idea that you could fire a shotgun through the front door and the pellets would travel straight through every room and out the back door without hitting a wall. Born from a combination of West African architectural influences and practical Caribbean adaptations to hot, humid climates, these houses were perfectly suited for promoting cross-ventilation, offering a cool refuge in an era before air conditioning. They were also an affordable and efficient use of narrow urban lots, making homeownership accessible to working-class families, particularly in growing cities like New Orleans, Charleston, and Louisville. However, as the 20th century progressed and city planning became more formalized, the very features that made shotgun houses practical also made them a target for reformers and officials. By the early 1900s, the style became heavily associated with poverty and, crucially, with African American communities, as many freed slaves and their descendants had lived in and built these homes. To the eyes of a new class of urban planners and zoning officials, who were often driven by a mixture of genuine public health concerns and deep-seated racial and class prejudices, the shotgun house represented everything that was wrong with older, blighted neighborhoods. The close proximity of the houses to one another, their modest size, and their high-density occupancy were labeled as overcrowding. The fact that they were often built on narrow lots right up to the property line was seen as a fire hazard. These concerns, while sometimes valid in cases of extreme neglect, were frequently exaggerated and used as a pretext for a broader agenda of slum clearance and racial segregation. This agenda culminated in the creation of explicit zoning ordinances designed to eliminate the shotgun house from the urban landscape. Cities began to implement minimum lot size requirements and minimum square footage mandates for new construction that were impossible for a traditional shotgun house to meet. A standard shotgun lot might be only 25 or 30 feet wide, but a new zoning code might require a minimum lot width of 50 feet. Similarly, a new code might demand that a house be at least 750 square feet, while many older shotguns were well under that threshold. These laws did not outright ban existing shotgun houses, but they made it illegal to build new ones or to replace one that was torn down. The effect was a slow, deliberate strangulation of the architectural style, ensuring that these communities would not be allowed to replicate themselves or grow. But the motivation went far beyond concerns about fire safety or square footage. The language used in city planning documents and newspaper editorials of the time often dripped with racial and class bias. Shotgun neighborhoods were described as slums, cancerous, and breeding grounds for disease and vice. The goal of these zoning laws was frequently stated as clearing blight and improving the character of the city, which was a thinly veiled code for displacing poor black residents and making way for new development that would attract a wealthier, white population. The destruction of historic shotgun house neighborhoods was a key component of urban renewal programs, and the construction of the interstate highway system, which often plowed directly through these communities, scattering their residents with little regard for the social and cultural fabric that was being torn apart. The legacy of this regulatory assault is a complex one. On one hand, countless historic shotgun houses were lost, and vibrant communities were dispersed. The laws succeeded in stigmatizing an entire architectural form to the point where many people for decades viewed these houses as valueless relics of a backward past. Yet, in a remarkable turnaround, the very qualities that made shotguns targets for eradication are now being rediscovered and celebrated. Their efficient use of space, their sustainable design promoting natural ventilation, and their historic charm have made them sought-after properties in many revitalizing urban areas. Preservationists now fight to protect remaining shotgun districts, recognizing them as invaluable cultural landmarks that tell a vital story of African American history and resilience. The story of the shotgun house ban is a powerful reminder that housing regulations are never purely about safety or aesthetics. They are often powerful tools of social engineering, reflecting the prejudices and priorities of the era that created them, with consequences that echo for generations. But the control over exterior color isn't unique to Santa Fe's historic adobes. This type of regulation finds one of its most common and powerful expressions in a far more familiar setting: the modern suburban homeowners association, where the color of your own front door can become a surprising point of legal contention. Across the country, countless HOAs maintain meticulously curated lists of pre-approved paint colors, and deviating from this palette, even for something as personal as your entryway, can lead to fines, legal threats, and a mandate to repaint. This goes beyond a simple preference for neutrals. Some associations have rules so specific they dictate that front doors must be a bold, accent color to add visual interest, while others insist they must blend seamlessly with the trim, leaving no room for individual expression. The underlying philosophy is a belief that uniformity equals stability, and that a cohesive streetscape, where every home looks like a slightly varied version of the same model, is the key to protecting property values for everyone. This obsession with door color taps into a deep and well-understood psychology of color in shaping our environment. Color is not merely decorative, it carries powerful emotional and symbolic weight. A community planner or HOA board often views a limited, harmonious color palette as a tool for creating a specific atmosphere, one of calm, order, and quiet sophistication. They might argue that a row of houses with doors in varying shades of navy, forest green, and burgundy projects an image of established, traditional elegance. In contrast, a sudden splash of neon pink or electric blue is seen as disruptive, even aggressive. It introduces visual noise and unpredictability, which can be subconsciously interpreted as a sign of instability or nonconformity, potentially making the entire neighborhood feel less controlled and therefore less desirable to a certain segment of homebuyers. The approved color list is, in their view, a defensive mechanism, a way to guard against the chaotic influence of a single homeowner's whimsy. The process of seeking approval for a non-conforming door color unveils the intricate power dynamics at play between an individual homeowner and the Architectural Review Board, often just a committee of volunteers who are also neighbors. A homeowner must typically submit a formal application, complete with physical paint swatches or digital renderings, and then wait for a verdict. This places the homeowner in a supplicant position, asking permission for a choice that, on any other piece of property, would be unquestionably theirs to make. The board's decision is often subjective, based on their collective interpretation of vague covenants about harmony and community standards. There are countless stories of boards rejecting a deep charcoal gray as too funereal or a cheerful sunflower yellow as too distracting, decisions that can feel arbitrary and deeply personal. This power can sometimes be wielded punitively, turning a simple request about paint into a weapon in a broader, unspoken neighborhood dispute, where a denied door color becomes a way to enforce social conformity or settle a score. For the homeowner on the receiving end of a violation notice, the experience can be profoundly frustrating. It reduces a decision that feels deeply personal, the color that welcomes you and your guests home every day, to a matter of compliance. What you may see as a tasteful expression of your personality, the board sees as a breach of contract. This clash highlights a fundamental tension in the concept of homeownership within a governed community. You own the deed, you pay the mortgage, but your ability to define your space is conditional. The front door, symbolically the threshold between the public world and your private sanctuary, becomes the very battleground where your individual identity meets the collective will. The fight over a can of paint is rarely just about the color. It's a microcosmic struggle over who truly holds the keys to your castle. Now, let's turn our attention to a housing concept that seems like an elegant solution to several modern problems, yet finds itself stifled by the very rules designed to organize our communities: the accessory dwelling unit, or a DU. Commonly known as a granny flat, an in-law suite, or a backyard cottage, and a DU is a small, independent living unit located on the same lot as a single-family home. It might be a converted garage, a basement apartment, or a newly built miniature house in the backyard. Despite their practical appeal, these small homes are outright illegal or so heavily restricted by zoning codes in countless American cities and suburbs that they might as well not exist. The origins of this widespread prohibition are deeply entangled with the history of 20th century zoning itself. In the post-World War II era, the dominant planning philosophy was centered on separation of uses. The goal was to create orderly communities by strictly dividing land into residential, commercial, and industrial zones. Within residential areas, the ideal was the single-family home on its own spacious lot, a model promoted as the hallmark of the American dream. Zoning codes were deliberately written to enforce this low-density vision. They included rules that mandated large minimum lot sizes, required significant setbacks from property lines, and, crucially, stipulated that only one single-family dwelling could be built per lot. The ADU, by its very nature as a second, smaller home on a property intended for one, directly violated this core principle. It was seen as a threat to the character of a neighborhood, a slippery slope toward the higher density and perceived chaos of urban apartment living. This legal framework was also shaped by less savory motivations, including a desire to exclude certain types of people. In the mid-20th century, restrictions on ADUs, along with other zoning tools like minimum square footage requirements, were sometimes used to price out lower-income households and maintain racial homogeneity in suburbs. By preventing the creation of smaller, more affordable rental units within established neighborhoods, these codes effectively ensured that only those who could afford a single-family home could live there. The term granny flat itself hints at a permitted exception allowing a family member to live nearby, but the laws were often crafted to prevent that unit from being rented to anyone outside the family, intentionally limiting housing options. However, in a dramatic shift, the last decade has seen a powerful trend of cities and states scrambling to legalize ADUs. The driving force behind this reversal is an undeniable crisis, a severe shortage of affordable housing, particularly in high-cost states like California, Oregon, and Washington. As housing prices have skyrocketed, ADUs have been rediscovered as a gentle-density solution. They allow for the creation of new housing without the dramatic change of constructing large apartment buildings. They enable seniors to age in place by providing a home for a caretaker or generating rental income, and they offer young adults a chance to live in their hometowns. For many homeowners, building an ADU represents a path to financial stability, offering a source of rental income that can help cover a mortgage or a means to house adult children or aging parents. Yet, the move to legalize ADUs has ignited fierce opposition, revealing a fundamental tension in community planning. Longtime residents often voice strong concerns about increased neighborhood density. They worry that quiet, single-family streets will be transformed by a constant influx of new residents, leading to more cars competing for limited parking spaces. There are fears about privacy as backyard cottages can overlook neighboring yards, and about the strain on public infrastructure like water, sewer, and schools. Some opposition is less tangible but equally powerful. It's a fear of change itself, a desire to preserve the familiar character of a neighborhood exactly as it is, which for generations has been defined by the primacy of the one house, one lot model. In response to these concerns, many cities that have legalized ADUs have done so with a web of new regulations that can sometimes seem as restrictive as the original ban. A homeowner might be allowed to build an ADU, but only if they agree to live in either the main house or the ADU themselves, a rule known as owner occupancy. There are often strict limits on the size of the unit. For example, it cannot exceed 800 square feet or 30% of the size of the main house. Parking requirements can be a major hurdle, forcing homeowners to pave over garden space to create additional off-street parking spots. These compromise regulations aim to placate worried neighbors by limiting the scale and impact of ADU development, but they also illustrate the ongoing struggle to balance the urgent need for more housing with the deeply held desire to maintain neighborhood character. The story of the ADU is a living example of how housing laws are not static. They are a constant negotiation, rewriting the rules of the American backyard in real time. But what happens when the source of a neighborhood dispute isn't something you built or planted, but the remains of something that once grew there naturally? This brings us to a uniquely specific regulation found in various municipalities across Pennsylvania, where homeowners can be held legally responsible for the lingering presence of a tree stump. In towns like Upper Moreland Township, for example, ordinances explicitly classify a rotting tree stump left on a property as a public nuisance, subject to fines and forced removal. The law shifts the responsibility for this natural artifact squarely onto the property owner, mandating its elimination once it crosses an official threshold. So, what exactly transforms a simple stump from a rustic garden feature into a legally defined nuisance? The definition is surprisingly broad and hinges on potential rather than proven harm. A nuisance stump is generally one that is deemed to pose a threat to public health or safety. This could be because it has become a breeding ground for pests like termites, carpenter ants, or rodents, which could then migrate to neighboring homes. A stump honeycombed with insect tunnels or hollowed out by decay can be a magnet for unwanted wildlife. The nuisance classification can also apply if the stump is considered a physical hazard. Perhaps it's located near a sidewalk where children play, presenting a tripping risk, or its remaining root system is suspected of damaging a neighboring foundation or public sewer line. In some cases, the mere perception of blight is enough. A decaying stump can be seen as an eyesore that detracts from the overall appearance and property values of the entire street, much like an overgrown lawn. The process of enforcement typically begins with a complaint. A neighbor who is concerned about pests or a code enforcement officer on a routine patrol notes the offending stump. The homeowner then receives an official notice from the local government, giving them a set period, often 30 days, to arrange for the stump's removal. This is not a simple suggestion, it is a legal order. If the homeowner ignores the notice, the consequences escalate quickly. The town will issue a citation accompanied by a fine, which can increase for each day the violation continues. In a final exercise of municipal power, the local government can hire a contractor to grind the stump out themselves and then place a lien on the homeowner's property to recoup the cost, plus administrative fees. This means that a homeowner who refuses to deal with a stump could eventually see a bill for the removal added to their annual property taxes, turning a simple landscaping task into a significant financial encumbrance. This seemingly minor law opens a fascinating window into the broader philosophical question of a property owner's responsibility for natural elements on their land. The legal principle at work here is that you are responsible for maintaining your property in a condition that does not negatively impact the surrounding community. This extends beyond just the structures you build to include the trees you plant, the ones you inherit, and even their decomposing remains. The law effectively states that nature, once it becomes a problem for your neighbors, is your problem to manage. This principle is why you can be held liable if a dead tree in your yard falls and damages a neighbor's house, or if invasive bamboo you planted spreads uncontrollably onto adjacent properties. The Pennsylvania stump rule is a logical, if somewhat extreme, extension of this idea, applying it not to a living threat, but to a dead one. The debate this stirs up is a classic clash of perspectives. From the township's point of view, it's a straightforward matter of protecting the common welfare. One neglected stump can become a nexus for pests that infest an entire block, or a safety issue that leads to a lawsuit against the municipality. Proactive enforcement is a way to prevent larger problems down the line. For many homeowners, however, the law can feel like a profound overreach. They might argue that a stump is a natural part of an ecosystem, providing habitat for beneficial insects and fungi as it slowly returns to the soil. To them, being forced to rent a heavy grinder or pay hundreds of dollars for a professional service to erase every trace of a tree can seem unnecessarily wasteful and contrary to a more naturalistic approach to landscaping. It becomes a battle between a sanitized, controlled vision of suburban order and a messier, more ecological view of property as a small piece of the natural world. This single regulation, focused on something as seemingly insignificant as a stump, perfectly captures the ongoing tension between our desire to control our environment and our place within the unstoppable processes of nature itself. And if you thought a town could dictate the color of your house or the height of your grass, wait until you discover the layers of regulation that can determine what goes right over your head, your roof. Across countless communities, particularly in regions prone to natural disasters or governed by strict aesthetic codes, the very material that shelters you from the elements is subject to intense scrutiny and often outright bans. These restrictions, enforced by city ordinances and homeowners associations alike, frequently target two common materials for very different reasons: the classic wood shingle and the modern metal roof, creating a complex puzzle for homeowners trying to balance safety, style, and compliance. The prohibition on wood shingles and shakes is most common and most justified in areas with high wildfire risk, such as California, Colorado, and parts of the mountainous West. The reasoning here is starkly pragmatic and rooted in tragic experience. Wood shingles, especially older, dried-out cedar, are essentially kindling waiting for a spark. During a wildfire, embers can travel miles ahead of the main fire front, raining down on neighborhoods. When these burning fragments land on a wood shingle roof, they can easily ignite the entire structure, turning a home into a total loss in minutes. The ban is not an arbitrary aesthetic choice. It is a critical public safety measure designed to create defensible space and slow the spread of fire, protecting not just one house, but entire communities. In these zones, homeowners are typically required to use Class A fire-rated materials, which include asphalt composition shingles, concrete or clay tiles, or certain treated metal roofs, all of which offer vastly superior resistance to ignition from airborne embers. However, the reasoning behind banning metal roofs is often flipped entirely, prioritizing aesthetics over raw safety. In many historic districts and upscale suburban HOAs, metal roofing is prohibited because it is deemed too industrial, too modern, or simply unattractive. The concern is that the reflective surface or distinctive standing seam profile will clash with the traditional architectural character of a neighborhood, whether that's a collection of historic Victorians or a sea of colonial-style homes. Critics argue that a metal roof can look out of place, potentially lowering the perceived value of surrounding properties by disrupting the visual harmony that covenants are designed to enforce. This creates a frustrating dilemma for a homeowner who might want the incredible durability, energy efficiency, and longevity that a metal roof provides, only to be told that their choice is unacceptable because it doesn't conform to a narrowly defined vision of what a roof should look like. For a homeowner navigating these restrictions, the path forward involves understanding the available alternatives and, in some cases, challenging the rules themselves. If wood shingles are banned for fire reasons, the most common substitute is asphalt shingles, which are cost-effective, widely available, and come in styles that can mimic the appearance of wood. For a more durable option, concrete or clay tiles offer excellent fire resistance and a distinct, often Mediterranean or Spanish-style aesthetic, though they are heavier and more expensive. When facing a ban on metal roofs for aesthetic reasons, the fight becomes more nuanced. A homeowner can appeal to the HOA's Architectural Review Board, often armed with research and samples. They might point out that modern metal roofing comes in a vast array of colors, finishes, and profiles, including styles that resemble traditional shingles or slate tiles, but with far greater longevity. They can also make a compelling case for the material's environmental benefits. Metal roofs are highly reflective, reducing cooling costs in the summer, and are often made from recycled content and are 100% recyclable at the end of their life, which can be 50 years or more. This clash over roofing materials ultimately highlights a fundamental tension in the philosophy of housing regulations. Is the primary role of these rules to ensure safety and mitigate collective risk, or is it to enforce a specific, often subjective, visual standard? The ban on wood shingles in fire zones is a clear example of the former, a necessary infringement on individual choice for the greater good. But the ban on metal roofs often represents the latter, raising difficult questions about whether aesthetic control should trump technological innovation and personal preference for a product that offers superior performance. It forces us to ask how much uniformity is truly necessary to protect property values, and at what point does that pursuit stifle progress and deny homeowners access to better, more sustainable ways to build and live. The battle over the roof is a quiet one, fought in planning departments and HOA meetings, but its outcome determines the very shield that protects everything underneath. But what about the equipment needed to bring the outside world into your carefully regulated home? This leads us to a fascinating conflict that plays out on balconies, rooftops, and exterior walls across the country: the battle over satellite dishes and television antennas. In an era where broadcast signals and satellite feeds are essential for news and entertainment, you might assume you have an absolute right to install the necessary receiver on your own property. The reality, however, is a complex tug-of-war between a powerful federal rule designed to protect consumer choice and the persistent efforts of landlords and homeowners associations to maintain their aesthetic control. The most important player in this conflict is a federal regulation known by the acronym OTRD, which stands for the Over-the-Air Reception Devices Rule. Enforced by the Federal Communications Commission, or FCC, OTRD is a remarkably pro-consumer law that specifically prohibits landlords, homeowners associations, and condominium associations from enacting or enforcing rules that unreasonably restrict the installation of antennas and dishes used to receive video programming. This includes traditional television antennas, satellite dishes like those from Direct TV or Dish Network, and antennas that receive wireless cable signals. The fundamental principle behind OTRD is that every American should have the ability to access the broad range of programming available over the airwaves and via satellite, a right that shouldn't be vetoed by a private governing body concerned about appearances. However, this federal protection is not an absolute free-for-all. The OTRD rule includes very specific limitations, creating a clear boundary between a resident's rights and a property manager's authority. The most significant limitation concerns size. For the most common type of dish used for direct broadcast satellite service, the law protects dishes 1 meter or less in diameter. For television antennas, the protected size is smaller at just 1 meter or less in any direction. Placement is the other critical factor. The rule applies only to areas where the resident has exclusive use or control. This means you have a clear right to install a dish on your own private balcony, patio, or yard. You can mount it on the exterior wall of your unit, so long as it's within the boundaries of your exclusive space. The law even allows for installations that involve drilling into the walls or other surfaces to secure the device, as long as the installation is safe and the resident is responsible for any damage caused. This is where the conflict intensifies, particularly for residents of condominiums, apartments, and townhouses. The concept of exclusive use becomes a legal battleground. A resident in a multi-story apartment building does not have exclusive use of the roof. It's a common area shared by all tenants. Therefore, the landlord or HOA can absolutely prohibit a tenant from going up to the roof and installing a dish there. They can also ban installations on shared exterior walls or in common hallways. For these residents, their right is confined to the often limited space of their balcony or patio. This creates a practical challenge. If your balcony is shaded, faces the wrong direction, or is simply too small to get a clear line of sight to the southern sky for a satellite signal, your federally protected right may be practically useless. Landlords and HOAs are often very aware of these limitations and will strictly enforce the boundaries of common areas to prevent what they view as visual clutter. The aesthetic argument from landlords and associations is a familiar one. They argue that a building dotted with a chaotic array of dishes and antennas of varying sizes looks unprofessional, messy, and dated. They claim this techno-blight can detract from the architectural integrity of the building and, ultimately, harm property values. In response, many associations have attempted to create centralized antenna or satellite distribution systems, offering a single, shared dish that provides service to all units in a clean, organized way. However, the OTRD rule also protects residents from being forced to use these often more expensive and sometimes limited association-approved systems. A resident has the right to choose their own provider and install their own receiver as long as it falls within the size and placement guidelines. This ongoing struggle is a perfect microcosm of the larger theme we've seen throughout this tour of American housing rules. It pits a federally guaranteed right of individual access to information and entertainment against the localized power of private contracts and aesthetic control. The OTRD rule represents a rare instance where a higher authority has stepped in to say that a certain level of individual convenience and choice is more important than perfect visual uniformity. Yet, through the clever use of property boundaries and the definition of common areas, landlords and HOAs continue to find ways to channel and contain that individual expression, ensuring that even in the realm of television reception, the battle over the appearance of your home is never completely over. Yet this intricate web of rules governing paint colors, fences, and even roof materials pales in comparison to one of the most universally enforced and critically important housing laws, a prohibition that exists in virtually every municipality across the United States: the absolute ban on using a storage unit as a living space. While it might seem like an obvious rule, its existence is a direct and grim response to desperate circumstances and tragic consequences. At its core, a self-storage facility is zoned and built for the containment of inanimate objects, not for human habitation. The law is unequivocal. Converting a 10 by 10 concrete box into a bedroom is not just a violation of a rental agreement, it is a criminal act. The reasoning is rooted not in aesthetics or property values, but in life or death safety concerns that make these spaces fundamentally uninhabitable. The dangers are numerous and severe, creating a perfect storm of hazards. First and foremost is the complete lack of ventilation. Storage units are designed to be sealed environments to keep out dust and moisture, meaning there are no windows that open and no air exchange systems suitable for breathing. A person living inside would quickly deplete the oxygen supply and succumb to carbon dioxide buildup, or be poisoned by fumes from any cooking source like a camp stove or even from a car engine running just outside the unit. Then there is the absence of plumbing. Without a toilet, shower, or running water, basic sanitation becomes impossible, leading to unsanitary conditions that pose a public health risk. But perhaps the most acute danger is the threat of fire. These units are often packed with combustible materials, old furniture, cardboard boxes, clothing, and papers. A single misplaced candle or faulty space heater could ignite a blaze that would spread with terrifying speed through the tightly packed, warehouse-like building. Compounding this is the fact that most storage units have only one entrance, the large rolling door, which can easily become blocked by fire, effectively trapping anyone inside with no secondary escape route. These are not hypothetical risks, they are lessons written in tragedy. In 2007, a fire at a storage facility in Miami claimed the life of a man who was known to be living in his unit. In 2019, a woman was found deceased inside a unit in Las Vegas where she had been residing. These incidents, and others like them, have cemented the legal stance and spurred facility owners to implement stricter security measures such as motion-activated lights, perimeter fencing, and rules against loitering after hours. The laws are a necessary, if blunt, instrument to prevent such fatalities, placing the responsibility on facility operators to ensure their properties are not used for purposes that are inherently lethal. Yet, to understand why someone would attempt to live in such a dangerous and inhospitable environment, we must confront the painful reality of extreme poverty and homelessness that drives this desperate choice. For a person with no other options, a storage unit can represent a perverse form of shelter. It offers four walls, a roof, a locked door, and a degree of privacy not found on a park bench or in a crowded homeless shelter. The monthly cost of a small unit can be significantly less than even a rundown apartment, making it the only housing that seems financially attainable. The decision is not born of ignorance about the risks, but of a harrowing calculation where the immediate need for safety from the elements and from other people outweighs the abstract threat of fire or asphyxiation. This stark choice highlights a devastating failure in the social safety net, where the illegal act of occupying a storage unit becomes a last resort for those who have literally nowhere else to go. The law, while essential for safety, ultimately does nothing to address the underlying crisis of housing insecurity that forces people into such dire circumstances in the first place. But the regulations governing our homes don't just control what they look like or who lives in them, they can also dictate what you're allowed to do inside them. This brings us to one of the most widespread and increasingly contentious areas of housing law: zoning ordinances that strictly limit or outright prohibit operating a business from a residential property. For millions of Americans working in the modern gig economy, the home is not just a sanctuary, it's their office, studio, or workshop. Yet, according to the letter of the law in countless communities, turning your living room into a corporate headquarters, even a one-person operation, can be a zoning violation. These restrictions are deeply rooted in the 20th century ideal of separating where we live from where we work. Traditional zoning was designed to create distinct districts, quiet, stable residential neighborhoods free from the noise, traffic, and commercial activity of industrial and retail areas. The primary concerns behind banning home businesses are disruption and preservation of character. Zoning boards worry about an influx of customer traffic, turning a peaceful cul-de-sac into a parking lot. They fear delivery trucks clogging narrow streets, strangers coming and going at all hours, and the potential for noise from industrial equipment or frequent client meetings. There's also a concern about commercial signage. A neighborhood of mailboxes and flowering shrubs is not supposed to also feature a neon, open sign or a placard advertising accounting services. The underlying goal is to prevent any single property from becoming a nuisance that degrades the quality of life and, by extension, the property values for everyone else on the block. This creates a legal framework with very specific and often very limiting rules. Many zoning codes draw a clear line between a home occupation, which is a low-impact business run by a resident, and a full-blown home business, which is typically prohibited. To qualify as a permitted home occupation, the venture must usually meet a strict set of criteria. There can be no employees other than residents of the home. There can be no visible evidence of the business from the street, meaning no signage, no display of goods, and no dedicated commercial parking spaces. Customer visits are often severely restricted, sometimes to just 1 or 2 clients per day, or banned altogether. The business cannot generate any additional traffic or noise beyond what is normal for a residence, and it cannot use more than a small percentage of the home's total square footage. Essentially, to be legal, your home business must be completely invisible to your neighbors and the outside world. This 20th century regulatory model, however, has collided head-on with the 21st century reality of work. The explosion of the gig economy, the normalization of remote work for large corporations, and the rise of e-commerce have fundamentally blurred the lines between home and office. Today, a person can be a full-time software developer, a graphic designer, or a financial consultant without ever leaving their house. An artist can sell paintings worldwide from a website managed at their kitchen table. A craftsperson can run a thriving Etsy store, shipping handmade goods from their garage. For these modern workers, their home is an integral part of their livelihood. The old zoning distinctions, which were designed for a time when a home business might have been a noisy auto repair shop or a bustling doctor's office, now feel hopelessly outdated and restrictive, punishing the very innovation and entrepreneurship that communities often claim to champion. This disconnect has sparked a wave of challenges and a slow but significant process of adaptation, as cities and towns recognize the economic and social benefits of supporting small business creation and allowing people to work from home. A trend massively accelerated by the pandemic, many are rewriting their zoning ordinances. The new approach often involves creating a more flexible category, sometimes called a home-based business permit, that acknowledges the reality of the digital age. These updated rules might allow for a small, tasteful sign, permit 1 non-resident employee, or acknowledge that a certain amount of client traffic is reasonable. The focus shifts from trying to ban commerce entirely to managing its impact, ensuring that business activities remain compatible with the residential nature of the area without stifling economic opportunity. Yet the tension remains palpable. For every municipality that modernizes its codes, there are others that cling to the old separation model. Enforcement is often complaint-driven, leading to situations where a successful entrepreneur finds themselves in a legal battle because a single neighbor objects to the occasional delivery van. This ongoing conflict highlights a fundamental question about the future of our communities. Will our housing laws adapt to support new, flexible ways of living and working, or will they continue to enforce a rigid, mid-century ideal that no longer reflects how many people actually build their lives and livelihoods? The answer will determine whether the American home can truly be a castle and a headquarters. So, from the color of your front door to the height of your grass, from the legality of your living arrangements to the fate of a tree stump in your yard, we've traveled through a truly astonishing landscape of American housing regulations. This wild journey reveals a nation in a constant, often clumsy, negotiation between two powerful forces: the cherished ideal of individual property rights, the notion that your home is your castle, and the competing demands of community standards, public safety, and a very specific vision of aesthetic order. It's a tug-of-war that plays out in city council chambers, HOA boardrooms, and courtrooms across the country, proving that the deed to your house often comes with a very long list of fine print. What's truly fascinating is that these laws, whether sensible or downright silly, are never created in a vacuum. Each one, from Santa Fe's earth tone mandate to Massachusetts' spite fence statute, tells a story about the fears, values, and social anxieties of the people and the era that produced it. They are a reflection of our collective attempts to solve problems, both real and perceived. Some, like bans on wood shingle roofs in fire zones, are born from tragedy and a clear need to protect lives. Others, like ordinances against sleeping in a doghouse or restrictions on front yard vegetables, are quirky relics of bygone eras or heavy-handed efforts to enforce a particular version of normality. Together, they don't just control what we can build or plant. They actively shape the very fabric of our neighborhoods, influencing who can live where, what our communities look like, and even how we interact with our next-door neighbors. The story of American housing is still being written. The recent, heated debates over accessory dwelling units and tiny homes show that this tension is more relevant than ever as we grapple with a severe housing crisis and a growing desire for sustainable living. The rules are evolving slowly and unevenly, but they are evolving. It begs the question, what strange housing laws are being drafted right now that will leave future generations scratching their heads? The conversation about what we can and cannot do with our own property is far from over. Now, we want to hear from you. This is just a snapshot of the weirdness out there, and we know we've only scratched the surface. What's the most bizarre, frustrating, or just plain hilarious housing rule or HO a regulation you've ever encountered? Have you received a violation notice for something you thought was perfectly reasonable? Share your stories in the comments below. Let's see just how strange it can get. And if you enjoyed this tour through the peculiar side of property law, make sure to subscribe and hit that notification bell for more deep dives into the hidden, surprising, and wonderfully weird facts about America. Thanks for watching.